Welcome to the Cyber Business Podcast, where we feature top founders and entrepreneurs and share their inspiring stories. Now, let's get started with the show.
Matthew Connor here, host of the Cyber Business Podcast, where we feature successful business leaders, top law firms, green energy companies, and more. Today, we're joined by the man who literally wrote the book on patent application. He's the co-author of the Patent Application Handbook, a patent attorney himself, and the founder of NovoTech Patent Firm. It's Babak Akhlaghi. Welcome to the show, Babak.
Thank you very much, Matthew. Happy to be here.
All right, before we get too far into the show, a quick word from our sponsors. This episode is brought to you by cyberlinks.com. That's cyberlynx.com. Cyberlinks is a complete technology solution provider that ensures your business not only has the most reliable and professional IT service, but also has the right cybersecurity solution to ensure your business stays productive and safe. All right, and now back to our show. All right, Babak, thanks so much for coming on the show. And for those who aren't familiar with you and NovoTech, can you tell us a little bit about it?
Sure, happy to. My name is Babak Akhlaghi. I'm the managing director of a patent law firm, NovoTech Patent Firm. We are located in Washington, D.C., which is not too far away from the patent office. We represent some of the largest companies in the world, but also many startups. Our firm is unique because we are mostly remote attorneys, and we save the cost of these fancy office spaces and pass them down to our clients. I would like to say what sets us apart are three main key factors. Number one, a strong technical background. Number two, a strong legal knowledge. And number three, flexibility.
So we love founder stories here. I mean, and by we, I really mean me. I love hearing just that whole journey and the how you came up with the idea, why you did it, going from the first dollar spent to the first employee to the second to the third. I love the whole process. I think it's fantastic. That for me, that's where all the excitement in business is how you went about it, the risks you took, the trials, the tribulations, all of it. I just love it. So let me ask you, 8 years ago, last month, what inspired the change? I mean, there you are sitting at in a very nice job, arguably a great job. Why the change, and what was the inspiration there?
There were a couple of reasons, couple of inspirations. I always wanted to create something of my own. I grew up in a family where both of my parents are lawyers, and they have their own firm. They live in Iran, so they're not here. I always thought I would like to build something of my own, and so the idea of forming my own firm was in the back of my mind. But I also understood you can't just start something. You have to learn from the people who have done this before. And the best place to learn is going to the law firm, especially a well-established law firm, and learning everything from seasoned attorneys there. And that's why from 2005 to 2015, about 10 years, I worked at two big law firms. One of them was a local national firm for a couple of years, prominent national firm, arguably number one firm in the United States. And then I moved on to the big international firm of a McDermott, Will & Emery, and I was there for a number of years until I became a partner. But I realized as I was working at these big firms that one thing was missing, and that is representing startup companies. My friends, and most of them often of the same mindset as me, having this entrepreneurial spirit and wanting to go on their own or starting their own businesses, they would often come to me and asking for if we can represent them in protecting their ideas, protecting their invention. And unfortunately, the answer was often no, because big firms are just not as structured to represent smaller clients, smaller startups, right? My hourly rate was $600-700 at the time. This is 10 years ago, and it just didn't make sense for the big firms. A startup couldn't afford it at one place, and my firm had this minimum budget requirement, and that was just not feasible for a startup. So I started thinking about, okay, what can I do to service these people and these clients? And I thought starting my own firm probably is a good idea, and that's what I did.
I love that. Well, let me ask you. So you've seen that opportunity and the desire really to help the small startup. What's that look like? I mean, let's say I've got this great new idea. I want to patent it. I want to start my business, but I know if I'm going to get funding, I'm likely going to need to protect the IP. How much should I look to have in terms of investing in securing a patent? What would you say would be a smart idea in terms of budget there?
Excellent question. And so one thing we have done at our firm, we have got rid of the hourly or billable requirements of charging per hour on a case. We have come up with a fixed fee for everything. So we have almost thought about everything that can happen in the life of a patent application, from drafting the application to submitting it to the patent office to fighting with the examiner to get the case allowed. We have thought about everything that can happen in this lifespan of a patent application and attach a fixed fee to it. So in a sense, we've taken the guesswork out for startups, owners and founders, because they want to know what are they in for. Yeah. And I would say obtaining a patent, I'll be honest with you, it's not a cheap process. It's expensive.
Of course.
But as we will see, is probably one of the most valuable assets of a company, more valuable than the equipment or the office space. IP is probably the intangible or the most valuable assets of the company. And this goes back to the flexibility I showed. We are flexible with our startups. So we work with the budgets. We know every client is different. Every client is unique. And if we have to come up with a flexible budget for them in order to make it work, we try to do that, particularly if we see, hey, there is a value here and they will remember us in the future. So I hope that answers your question.
I love that. No. I think that's great, because I think that's the big concern. It's going to be a lot of money, but it's a value add. Without that, you have the best idea in the world, but if it's not protected, somebody just can come in and take that. And so, which I think kind of leads me to another question I have, is that when it comes to patents, right, and defending these patents, and we think about today you've got these massive companies like Google and Samsung and Apple, who are notorious about being really good with their patents, and then they fight amongst themselves with patents. So if you're a little startup guy, you've got the next, let's just say it's a game-changing idea. I come to you with my game-changing idea. Here it is, Babak, can you help me? How do we protect this? And then is it something that we can defend, or in the end, a big guy is just going to destroy us because we're little and they can take it and run with it? Is it that we live in a land of Goliaths now that can just, walk all over all the little Davids as much as they want? Or are you the David that protects, all us little guys? How's this work?
Excellent question. And defending a patent against large corporation is certainly possible. Okay, so the size of the company does not negate your patent rights. It just doesn't come into a factor. However, it's important, right, to note that such legal battles can be very expensive and time consuming. And the big companies have the resources, the little guys don't. But it's crucial to have an experienced patent attorney to guide you through the process. There are patent firms that take cases on contingency. There are patent firms that defer payments until some funding comes through. I tell you a little story. I represented a startup, and they had this amazing technology, and they sued a couple of big corporations. And naturally, the big corporations try to invalidate the patents, as often happens in the realm of patent infringement. You sue for a patent, they countersue, or they say, the patent is invalid. So the part I was involved is defending the validity challenges of this big corporation against this startup. And I was going back and forth with the patent office on why this patent is valid, is still valid, should not be invalidated on any new grounds that are being proposed. And we were successful. And that resulted in close to $1 billion, hundreds of $1 million in judgment for this small startup. So is it possible? Absolutely it is.
Wow.
Is it difficult? Absolutely, you're right. Is it expensive? It is. But it's worthwhile at the end of the day.
Yeah. And I suppose this is, if you're this small guy who's come up, I've come to you with my great idea, you've gotten me the patent, 6 months later, and I'm not going to pick on Google, but let's pick on Google. Google comes in and says, nope, they say that they're going to use that. And we're like, hey, wait, that's our technology. Is this something where your firm's kind of flexibility it comes into play, and you're like, hey, look, we can find you financing. We can maybe help you. Is this something where you'd be able to help help me out with something like that?
So excellent question. And I have to say, to clarify my earlier story, this was a time that I was at a big firm.
Right.
So since we have started this law firm, we focus only on obtaining a patent for our clients, not defending against already obtained patents. So, but there are scenarios in which the startup comes to us and say, hey, the budget is tight right now. Can we work on some sort of a deferred payment plan? That's where we work with them. Can we reduce? Can we provide some sort of a discount? That's where we work with them. But we have our niche area. We focus exclusively on our niche area, and that's what we're really good at. Drafting a patent application to protect the invention and fighting with the patent office to get it allowed. Once the patent is granted and it goes through a litigation, we do have a strategic alliance with larger law firms, like international firms, that are capable of litigating or defending, that we can refer the startups to.
Right. And that makes sense. And the reality is you need to have that kind of airtight patent, that's easily can be defended, versus one that you kind of threw together yourself. And so and then it gets torn to shreds because, well, I'm a smart guy. I came up with this technology. I can fill out this patent form, right, and submit it. But let me ask you. So in that case, what advice would you give to, a young or even seasoned inventor who's got a great idea? What are some of the mistakes that I would probably make if I filled out, tried to submit my own patent application? What's your advice? I mean, you've been doing this forever and a day. You're the expert. What would you tell the young inventor?
Don't do it.
Sage advice.
Don't do it. Okay, but let me expand on that. Well, it is technically possible to file a patent application on your own. Okay, but due to the complexity and specificity of patent law and the requirements of application itself, It's just generally not recommended for you to do it on your own. I would strongly encourage you to find a capable patent attorney to handle your invention. And not any patent attorney, a patent attorney that has a relevant technical background in your invention. So for example, if your invention is in electrical engineering and or software, find a patent attorney with a background in electrical engineering or computer science. Whereas if your invention is in the chemical realm, find somebody with a suitable background in that area. Because mistakes in patent applications can be fatal, especially drafting claims, which are the most important part of a patent application. Just like drawing. You can draw something, but the quality of that drawing is extremely important. That's what sets apart the valuable patent versus the one that doesn't have a value.
Yeah, no, that's a great point. And I would imagine there are loads of stories about a missing comma or an ambiguous word that ends up costing somebody, millions, if not billions, because they just chose the wrong word, or they didn't put in a comma and it misled people to interpret it differently. Is that about the case?
Exactly.
Yeah. To me, that sounds like, the stress level of making sure that everything is done so perfectly kind of reminds me of it's kind of like the business and legal version of being in the operating room. The stress level, I couldn't do it. The stress level is so high. I mean, we do it on the IT and cybersecurity side, and we kind of treat everybody's problem as like a five alarm fire, and it's like it's life or death, just because I think we should take on their stuff. But I couldn't imagine, like, when you're in the operating room and you got life on the line, that stress is so higher. When you're doing patent applications, the risk is so high to have everything so right. How do you deal with that level of stress, really, right? I mean, because that's what it comes down to. Is it just the years of experience that you know your stuff, so it's not as stressful anymore?
Correct. Years of experience. I have to say, when I started, it was extremely stressful drafting claims or drafting a patent application. Mm-hmm. But as you do it more and more, it becomes natural. It becomes a habit. And you immediately start seeing things that you weren't seeing before. Things start falling into place. But also, having a technical background is essential to be able to understand what the inventor is saying and to be able to capture that invention the way it should be captured.
Yeah.
Because sometimes we, as patent attorneys, one thing that we do, and this is another value add that we provide, is that we help the inventors invent. We see things because we share the same technical background as the inventor. We see things when they tell us the invention, we just don't put that in the application the way they tell us. We ask them, what about this other way? What about this additional implementation? Have you thought about this other implementation that's possible? And all of a sudden, the inventor's mind, the wheel starts turning. Like, yeah, I think it can work this other way too. And then they tell us additional information. So we kind of pose specific questions that help them to fine-tune their invention.
Wow. I never would have even thought of that. I mean, you think of the patent attorney as just, the one who kind of fills out the form really well for you to save your bacon in the future, not as, a kind of value add in the inventing process and because really in the end, if somebody can take a look at what you've invented and apply it in a different way than what you were thinking, right, then they may be able to walk away with your patent, with your intellectual property, and not pay you a dime. But you're saying that I could get in the right help with that to see it from another perspective. I mean, wow, I never would have thought about that. That's brilliant. That's fantastic.
That's absolutely right. So we try to come up with the various alternatives and to cover that in a patent application. So as you mentioned, somebody else looking at the claim and trying to what we call design around it cannot do so easily. So because we have already gone to that process of thinking about design around. But not only that, when you file a patent application with the patent office, you never know what the examiner is going to throw back at you, right? The sea of prior patents, prior publication is so vast that we like to do a patent search before we file our application, right? To make sure, hey, this idea is novel, makes sense, it's new, but it's just impossible to find everything. There is no way, nobody can do it. If anyone tells you I'm going to find everything, just take my word, it's impossible. Some of the things are not even published yet. So that can be used against you, because by the time you file your application with the patent office, it takes about 18 months for that application to become published and used against other applications. So it's never clear what the examiner is going to throw at you. So it's always good to have backup option, alternative options, additional implementation. So if your implementation A, the examiner says your implementation A is shown in this prior patent, and let's say the examiner is right, you have an implementation B, you have a plan B, plan C. So when the inventor, the startup that is putting a lot of money, every dollar counts for startups, into this patent application, they can get something valuable at the end of the day from the patent office.
That's great. Well, let me ask you. So you guys, you mentioned earlier that you cover a variety, a number of different, I guess, areas, if you will, whether it's software or electrical design. What fields do you really are your kind of your specialties, and who are your ideal clients?
Excellent question. Let me take the second question first, and then I go to the first one. We represent clients from all walks of life, from 100 company, Fortune 100 companies to ambitious startups. And all of them are unique. But all of them share one common interest. And that is they have an innovative idea that they're looking to protect. They value professional guidance and are committed to understanding and participating in the patent process. So that's our clientele, mostly startups and big companies with innovative ideas. The technology space that we work in mostly is software related. So from machine learning, AI, to iPhone applications.
Got it. So, I mean, I guess that is kind of what you'd picture for most patents these days, right? I mean, a lot of it are new apps, new software. It's the hardware part. Sure, there are tons of that, but that's probably not as big a business as the software these days. So you'd say most all of your business now is focused around is software. That's where the majority is coming in.
Significant portion. We still represent a lot of hardware cases, but a significant portion of our application are in the software domain.
Nice. Let me see. Yeah, no, that's fantastic. So what would you say are some common mistakes? I know you've given some advice, but are there some common mistakes that startups often make, whether it's in the initial preparation, in thinking? What kind of common mistakes do you guys often see that people can try to avoid?
There are some common mistakes. There is a right way of going about this. There is a wrong way of going about this. Let me just quickly tell you the right way, because I want to emphasize that. Yeah. And then we work into the wrong way of going about protecting inventions. And we can talk about other IP types too, if that's of interest. When we talk about patent inventions, patents are just your best friends. If you have an invention, start by conducting a patentability search. You can do this by yourself, right? You can do a Google search to see if something out there that is similar to it. Once you are in the clear, file your application. Then and only then you should focus on raising capital and marketing your invention and telling the world what a great idea you have. And this is the right way of going about it. Now, let's look at the common mistakes or the wrong way of going about it. Picture this. You come up with an amazing invention and get all hyped up about it, and immediately you start seeking capital and marketing it and telling friends. And then it hits you. Someone else is copying your product and selling it at a fraction of the cost all the way from China. Panic sets in, and you think about protecting your invention by filing a patent application. Well, my friend, it's often too late by then. You see, the patent office has certain rules in place that might make it impossible for you to secure patent after the fact. So you ask me about common mistake. One of the most common mistake I see, and some of the startups come to us, we have to reluctantly tell them, sorry, we can't do anything, is self-imposed mistake. That is, they publicly disclosed the invention more than a year ago. They offered it for sale more than a year ago. They start using it more than a year ago. All of these are what we call a patent-defeating events. So thankfully, the United States Patent Office gives you 1 year to file your application from a public disclosure, public sale. But it's just better not to disclose anything publicly. And by public, again, I got to be a little bit specific here. It doesn't mean you disclose to a lot of people. It just means disclosure that is not subject to an NDA, non-disclosure agreement. So even disclosure to a small group of people at a conference can be considered public disclosure. So don't do that. File your application first. There are ways to do it in cheap price, significantly cheap price, like by filing what we call an informal application, a provisional application. And then you can start raising capital. Then you can tell friends. Then you can start marketing it, selling it, or start using it. Another common mistake I see, and it's happened a lot with the startups, is when the startups hire contractors or employees who invent, but there is no IP provision in their agreement with the startup, in their employment agreement. And then the whole question comes up, who owns this IP?
Right.
And they have to pay at that point a significant amount of money to that contractor to obtain the IP. Sometimes this comes up when the startups start engaging with another company in building their product. And the other company come up with additional enhancement to the product. And then the question comes up, well, who owns this additional investment? Again, all of these can be avoided upfront if there is a good agreement, IP agreement in place between your employees, between your contractors, between your vendors, if you will. So these are really the common mistakes I see. And this one is probably obvious, but I say it because it happened. And getting a patent application, we talked about it, is an expensive process, right? It's not cheap. But as someone who works with the startups, and I know every legal dollar counts. If you're a startup, it's not really necessary to hire big law firms that just charge such a high amount for their junior associate and fancy office buildings. Instead, I would encourage you to focus on hiring seasoned practitioners, those that have worked at the law firms, large law firms, that have gone to a smaller firm or have gone to open their own shop. They should be able to give you a fixed fee or charge you at a fraction of the cost and protect your idea. And true story, a startup owner shared a painful lesson with me. They spent about $40,000 to a big firm to just draft bylaws and to form the company and establish bylaws, and left almost no money for the company to actually build the product that they wanted to build. So be mindful of that. Again, it's important to go with the quality, but the quality is not in the name of the firm. The quality is in the patent attorney and the relevant background, and whether he's a seasoned attorney or she is a seasoned attorney.
That's great advice. And I think I don't know that it necessarily comes down so much to cost as it really is about value, and so obviously a patent is going to cost, money, and you want it to be you want to get the most value for your investment. You're investing in protecting your IP, and you need to make sure that that's a good investment. If you put it into, let's say you just get some attorney who, yeah, I can do a patent for you, and they're just really inexpensive. That might be a worthless patent. They may have made all kinds of mistakes, and it gives you no protection. Yeah, and anybody with patent experience, you go to raise some funds, or you run in, God forbid, you have to defend that patent, and now it's worthless, and you've wasted, $10,000-$15,000 instead of investing in a good patent attorney. And on the other side of that, obviously, you go to some large firm, forget about it. You don't have that kind of, you don't have the $250,000 you're going to need, to get your patent. That's just crazy talk, right? Especially somebody who can burn through $40,000 in bylaws. Whew, that's crazy.
Yeah.
I mean, what is that? That's like an hour-long conversation. Boom, bylaws done. That should cost you a few $100, maybe 40 grand. I don't know how you stretch that out. That must have been a very complicated company. That's crazy. But no, I love it. Yeah, go ahead.
Sorry, I think again, you touched on a good point. If you look at this from a cost-benefit analysis, that you are creating something of value, you are creating an asset. Yeah. Patents are like, it's like deed to a land, right? You have a home, you have a deed to your property, and because you have a deed to your property, you own that land, and you can put a fence around it to avoid trespassers from coming in, right? So, and patents are very much the same. They are these metaphorical virtual fence around you. They create this virtual fence around your invention, and it helps you prevent from other people from using, marketing, and selling that invention. So what does that mean? That means you have created an asset, just like you have bought a property. Let's say you bought an office building or you bought a home that you can utilize to create additional revenue for the company. It's now common for patent to be used as collaterals with a bank to get a loan. If you go on a USPTO website, large or a small company, doesn't matter. A lot of patents are recorded as collaterals for loans. They can attract investors. I don't know if you like to watch Shark Tank, but I watch it sometimes. And one of the questions they ask is, but I couldn't help but to focus. Shark would start flowing behind you as soon as I said
it was. Yeah.
So one of the first questions they ask is, "Do you have a patent?" And the reason they ask is because they want to make sure nobody else is going to copy your product and steal its success. So a patent not only validates the uniqueness of your product, that nothing else out there is like it out there, but it also safeguards the investor's interest in your company.
Absolutely. Sorry, go ahead.
And I think one other thing I would say about patents and its benefits it helps you boost your profit. With a patent, you have the right to exclude others because of that virtual fence it creates around your invention. So that exclusivity allows you to set your own price and charge a premium for your product.
Well, I'm glad you brought up Shark Tank, and I think you kind of almost answered the question I'm about to ask, but I want to bring it up. So Mark Cuban is pretty, and I'm sure you know this. He's got a pretty strong stance on being anti software patents, and I think I see why, and I think you've just kind of alluded to it. I think he doesn't like the that sort of exclusivity that it grants anything and whatnot, and he thinks that the market should be the one to decide what technology wins and dies. But what's your response to that? I mean, he's obviously anti. What would you say to somebody who's like, well, Mark Cuban's made a lot of money. He's a smart guy. If he thinks software patents are a bad idea, maybe I shouldn't get one for my software.
My response to that goes back to the principle of patent laws. Patent laws are there to encourage innovation. They are not there to discourage innovations. They are there. The whole premise of a patent system is that to give the inventor an incentive to disclose their idea. The government says, disclose your idea to the public, so they can read about your idea on a patent publication. And what does that do in return? It helps other people to invent, because they look at that idea, it's like, oh, this is a great idea. And but it would have been even better if it had been modified to include this. So the government says, disclose your idea, and in return, I give you 20 years exclusivity to this idea. Again, it's 20 years, it's not a lifetime. So after 20 years, it becomes part of a public domain. So my response to that is, if we do take patents out for software or anything else, if that argument were to apply, you would apply it equally to all patents, drugs, for example, right? Because companies spend a lot of time and resources to come up with these ideas. If they can't protect it, then you take that incentive away. Why would they innovate? So that would be my response. And the economy would not, the technology knowledge base would not evolve as it does. And I think that's one of the reasons you see the United States have such a strong patent system and being technologically so advanced compared to the countries that do not have a strong patent regime in them.
Yep. No, I couldn't agree more. Well, and I think we could go on and on pretty much all day like this. This is fun stuff. But before we wrap up, can you tell everybody where they can find out more about you and your company?
Sure. You can contact us at our website. You can reach us via our website, www.novotechip.com. And our profile is there. Each of our attorneys' profile is there. And feel free to reach out to any one of us. And my email address is my last name at novotechip.com. And if you have any questions, feel free to reach out. I'd be happy to have a free consultation video. And I'm sure there are a lot of law firms, hopefully there are, that provide a free consultation. And at least that would help you go the right way about protecting your intellectual property.
Fantastic. Well, Babak, thanks so much for coming on and sharing all of this great information with us. We will have links to everything below, of course, and on our website. And it was just a pleasure hearing about it. And it was great talking today.
Likewise, Matthew. Thanks for having me again.
Thank you.
Thanks for listening to the Cyber Business Podcast. We'll see you again next time, and be sure to click subscribe to get future episodes.